Welcome to the channel and thank you for choosing to watch this video. My name is Jonathan and I work in the offshore global business industry. In this video, we will cover private company shareholders by first going over what shareholders are. Then we will dig into the understanding of shareholders. Third, we will cover special considerations assigned to shareholders based on company laws. And since I work in Mauritius, we will cover some of the sections of the Mauritius Companies Act 2001 regarding their statutory rights and obligations in terms of their liabilities and powers. Fourth, we will globally touch upon meetings of shareholders that are supposed to be held at least once annually. And finally, we shall glance into the key takeaways surrounding shareholders. I hope you enjoyed this video, and as usual, I wish you a reflective and insightful viewing. Regarding private companies, a shareholder refers to an individual, entity, or organization holding at least one share of a company's total issued or outstanding shares. Shareholders hold ownership stakes in a company, entailing specific rights and obligations. This ownership grants them the opportunity to partake in the rewards of the company's accomplishments. Such rewards may manifest in a distribution of financial gains through dividends. Conversely, in instances where a company experiences financial losses, this may lead to and result in potential monetary losses. Shareholders may also be referred to as members of a company, and this is the case in various jurisdictions. A person or legal entity becomes a shareholder in a company when their name and other details are entered in a company's register of shareholders or members, following the necessary statutory filings having been filed with the competent authorities, which in Mauritius would be the Registrar of Companies. At the end of the day, shareholders are simply the legal owners of a company. That is as simple as that. As previously stated, a shareholder or member denotes an entity that possesses one or more shares within a company's total issued or outstanding shares. This ownership status endows shareholders with a spectrum of rights and responsibilities. Beyond merely reaping the benefits of the company's prosperity, shareholders play a pivotal role in the governance and decision-making processes. Specifically, they have the privilege to exercise their voting rights on significant matters that impact the trajectory and operation of the company in which they have invested. These matters may include electing members of the board of directors, approving corporate initiatives, and ratifying fundamental company policies. Within the realm of shareholder ownership, distinctions arise based on the magnitude of ownership held. A shareholder who acquires and maintains control over more than 50% of the company's outstanding or issued shares earns the designation of a majority shareholder. This pivotal status empowers them with significant influence over corporate decisions and strategic directions. Conversely, individuals or entities whose ownership stake falls below the 50% threshold are categorized as minority shareholders. Despite possessing less substantial ownership stakes, minority shareholders still hold certain rights, such as receiving dividends, attending shareholder meetings, and accessing financial information about the company. However, their influence on decision-making processes is typically more limited compared to majority shareholders. Understanding these distinctions is paramount for comprehending the dynamics and governance structures within shareholder-owned entities. Most majority shareholders typically emerge from the company's founding members. In more established companies, majority shareholders often maintain a familial or direct association with the original founders. In both scenarios, these shareholders possess significant influence over critical operational decisions, such as the replacement of board members and high-ranking executives, like chief executive officers, provided they control over 50% of the voting interest, or as may be provisioned for in the company's constitution or memorandum or articles of association, as the case may be. Unlike sole proprietors or partners in partnerships, corporate shareholders benefit from limited liability, shielding their personal assets from the company's debts and financial obligations. Consequently, in cases of insolvency, creditors cannot pursue a shareholder's personal assets for debt settlement. Several factors warrant consideration for individuals contemplating becoming shareholders. These encompass the rights and obligations inherent in shareholder status, as well as the potential tax ramifications associated with such ownership. In accordance with a company's constitution or memorandum or articles of association, as the case may be, and bylaws, shareholders traditionally possess a spectrum of rights aimed at safeguarding their interests and ensuring transparency. These rights include: Number 1. The right to scrutinize the company's books and records, enabling shareholders to monitor the company's financial health and performance. Number 2. The authority to initiate legal action against the company for the wrongful actions or negligence of its directors and/or officers, safeguarding shareholders' interests and holding corporate leadership accountable. Number 3. The privilege to participate in key corporate decisions through voting rights, such as electing board members and approving significant transactions, or otherwise known in Mauritius as major transactions under Section 130 of the Mauritius Companies Act 2001, like mergers and acquisitions, empowering shareholders to shape the company's strategic direction. Number 4. The entitlement to receive dividends, if declared by the board of directors, as a share of the company's profit, serving as a tangible reward for shareholders' investment and ownership. Number 5. The right to attend annual meetings, whether in person or via remote means, such as conference call, enabling shareholders to engage directly with management, receiving updates on the company's performance, and exercising their voting rights on critical matters. Number 6. The option to vote on important matters by proxy, utilizing mail-in ballots or online voting platforms if unable to attend voting meetings in person, ensuring that shareholders' voices are heard even in their absence. Number 7. The right to claim a proportionate share of proceeds in the event of the company's liquidation, providing a measure of protection for shareholders' investments in situations where the company dissolves its operations and distributes its assets. These rights collectively serve to uphold shareholder interests, promote accountability within corporate governance, and foster transparency in the management of corporate affairs. Understanding and exercising these rights are essential components of effective shareholder stewardship and engagement in corporate decision-making processes. Lastly, as mentioned in the intro to this video, the following sections of the Mauritius Companies Act 2001 apply to rights and obligations of shareholders of companies in Mauritius. The meetings of shareholders in private companies serve as pivotal gatherings where shareholders convene to address various aspects of corporate governance, financial performance, strategic direction, and other critical matters pertinent to the company's operation and growth. Unlike public companies, which often hold widely publicized annual general meetings known as AGMs to engage with a broader base of shareholders, meetings in private companies tend to be more discreet affairs, typically organized at the discretion of the company's leadership and in compliance with the company's bylaws and applicable legal requirements, such as is the case in Mauritius. To hold an AGM, this is under Section 115 of the Mauritius Companies Act 2001. These meetings provide an opportunity for shareholders to receive updates on the company's performance, financial health, and strategic initiatives directly from the management team. They may include presentations, reports, and discussions on topics such as financial statements, operational highlights, market trends, and future prospects. Shareholders may also have the opportunity to ask questions, voice concerns, and provide input on key decisions affecting the company's trajectory. In addition to receiving information and updates, shareholder meetings in private companies often involve voting on significant matters requiring shareholder approval. These may include the election or removal of directors, amendments to the company's constitution, or memorandum or articles of association, as the case may be, major business transactions, changes in capital structure, and other matters of corporate significance. Each shareholder typically has voting rights proportional to their ownership stake in the company, although specific voting rights may vary depending on the company's organizational structure and shareholder agreements, or whether such shareholders do actually hold voting rights, as some types of shareholders do in fact not possess any voting rights, but the rights to financial distributions or dividends only. More on this in another video. Moreover, shareholder meetings serve as a platform for fostering transparency, accountability, and trust between the company's management and its shareholders. By providing shareholders with opportunities to engage directly with the leadership team and participate in decision-making processes, these meetings help strengthen the alignment of interests between shareholders and management, promote shareholder activism, and enhance corporate governance practices. Overall, while the format and frequency of shareholder meetings in private companies may vary depending on the company's size, industry, and specific circumstances, these gatherings play a vital role in facilitating communication, collaboration, and collective decision-making among stakeholders, thereby contributing to the long-term success and sustainability of the company. A shareholder, whether an individual, a corporation, or an institutional entity, holds ownership in a company by possessing shares of total issued or outstanding shares. This ownership status is not contingent on the quantity of shares owned. Even ownership of a single share confers shareholder status upon an individual or entity. Shareholders tend to realize capital gains or losses depending on the overall financial performance of a company. Additionally, shareholders may be eligible to receive dividends, which are periodic distributions of the company's profits to its shareholders. These dividends serve as a form of reward for their investment and ownership in the company. Furthermore, shareholders hold certain privileges and rights within the company's governance framework. These include the right to participate in crucial decision-making processes through voting at shareholder meetings. Key matters subject to shareholder approval may encompass the election of members to the board of directors and the approval of mergers or other significant corporate transactions. Such participation empowers shareholders to have a direct say in the direction and management of the company, ensuring their interests are represented in corporate decisions. However, it is crucial for shareholders to recognize the inherent risks associated with their investment. In the event of a company's bankruptcy or insolvency, shareholders are among the last in line to recover their investment. In such dire circumstances, shareholders may face the possibility of losing the entirety of their investment, as the company's remaining assets are typically allocated to creditors and other stakeholders with higher priority claims. This underscores the importance of conducting thorough due diligence and risk assessment before investing in company shares, as well as maintaining a diversified investment portfolio to mitigate potential losses. Thank you so much for watching this video until the end. This is once again hugely appreciated by me, and I hope it provided you with valuable information, insights, and key takeaways. As always, I will be posting frequent and insightful content, so feel free to come back to the channel for more videos concerning the offshore, global, and financial services industries. Stay safe and healthy, guys. I'll see you in the next one. Cheers.